Welcome, those of you tuning in on the web, on Facebook. So happy to have you with us today, this evening actually, here from my conference room. And this is where we meet with a lot of clients to talk about wills and trusts, estate documents. So honored to have you here with us today. Honored to have everyone. If you were here, you could drink Starbucks coffee and eat some chocolate chip cookies from the community bakery. But you can do that next time. This will not be our last webinar on this topic, and we'll do other topics as well from time to time. But this is an important one. We also covered this in another webinar back in October. I'm not going to repeat all of the information. I will repeat some of the information, but you can always go to our YouTube channel, The Bible, the Basketball, and the Briefcase, and you can find the information there on our YouTube channel. You can watch the whole webinar. I think it's about 30 minutes from the last time we did this, and it will get into some information, a little more in-depth information probably than what we're going to cover tonight. Also, we have the Bible, the Basketball, and the Briefcase podcast that we do every week. Usually at the end of that podcast, we talk about some area of the law that we practice or just some information that would be helpful to people and maybe to you, maybe to your family. So feel free to tune in anytime for that event. We usually post those on the channel, the YouTube channel, on Mondays, sometime usually between 8 and 5 on Mondays. So love for you to tune in anytime to watch those. We also try to post clips with just the law, the briefcase part of the podcast, the law as well, and try to provide good content that tries to answer questions and helps you as you navigate life. The law comes up in life, and particularly in this area. It's an important part of our practice here. I've practiced law for over 28 years, and during that time, I have done a lot of probate cases. Probate is where you have to go file a will. You have to go through an entire probate process, which just kind of to give you some information, this is kind of the other side of if you don't have a revocable trust to avoid the probate process. So what happens is that when your loved one passes away, you usually bring the will to the attorney preparing the will. And I've had lots of clients bring me the original will. We take that original will along with a petition for the appointment of the personal representative of the estate, which usually the will names the personal representative, the executrix, or the executor of the will. And we file the petition, we file the will, we file a copy of the death certificate, and then we begin what usually is at least a 1 year to 1.5 year process to probate that will. After we file the petition, we get the personal representative appointed, then we file an acceptance of the appointment, and then once we do that, we get letters testamentary, which is how the personal representative does business on behalf of the estate. We get a tax ID number for the estate so that an estate bank account can be opened and monies from the estate can be placed in that account. We also publish notice in the newspaper, usually the Democrat Gazette, for 2 consecutive weeks, and unknown creditors have 6 months from the date of first publication to file a claim against the estate. I have people come to me all the time and say, well, I know my dad didn't have any creditors, so we won't have to do that. I said, no, the statute requires that in every case we publish notice in the newspaper, because if they are an unknown creditor, you guessed it, we don't know about them. So that's why the statute requires that we publish notice. We have to give specific notice to known creditors, and so you have to calendar off 6 months. Time that an unknown creditor can file a claim against the estate. During that time, though, we try to assist the personal representative in fulfilling all of their duties. There's a duty to inventory the estate. I have been lately hiring an auction company to assist with that where the parties desire to sell a lot of the personal property. Most of the time they will actually do the inventory for the personal representative, which is really handy, especially if you have a loved one that has a lot of tools or the kinds of things that are really hard to really know what the value is and to try to account for each item. And you don't necessarily have to give an account for every wrench, but when you get these companies involved, they do. They actually do. So it's very helpful, and usually they do an estate sale and keep a percentage of what they sell for their pay. And so it's many times it's a really good option. We do have to file a petition with the court for permission from the court to allow us to sell the personal property through an estate sale. And courts are usually pretty good about doing that as long as the monies go from the sale of the personal property into the estate bank account that I talked about earlier. Also, during the pendency of the estate, you can sell real property. You can sell the estate home if the home is going to be sold. Sometimes the heirs are left the home itself, and there's a desire from the deceased person that the home not be sold. That's usually pretty rare, and usually for purposes of paying expenses, the home is sold and the proceeds divided as is specified in the will. So you can file a petition during the pendency of the estate for the sale of the real property. You have to get court permission. You're supposed to get more than one disinterested appraisal of the property. And many times, if everyone agrees, we just get one, but the statute requires more than one appraisal of the property. And the property has to sell for 100% of the price value, which can be helpful or it can hurt you in trying to sell real property. If you have a motivated purchaser and you tell them, hey, the appraised value is whatever it is, and I am told I have to sell it for 100% of the appraised value, you're in a pretty strong bargaining position if they really want the property. Depends on the market and a lot of things, but often we will sell real property during the pendency of the estate and put the proceeds in the estate bank account. So by the time the 6 months has expired for unknown creditors to file claims against the estate, we have filed an inventory, which is always due prior to the expiration of those 6 months. Then we get ready to prepare the final accounting. If there's a request for an accounting earlier than the final accounting, then this would be, it may be the final accounting, but it may be the first and final accounting. Many times it is. And so we have to give an account for all of the personal and real property that's placed in the hands of the personal representative. So we have to go through, it's just kind of like you would think of an accounting. You have to provide an accounting. Usually by this time you're dealing with money a lot of times, and you deal with the expenses of the estate, the attorney's fees, all of the expenses that have been paid from the estate, all of the monies received, whether it's through the sale of personal or real property. If there is still actual land and houses that have to be deeded, then you have to indicate that in the accounting, although obviously it's not anything that can be accounted for because it's not a liquid asset. But you file that, and unless there's an agreement, if there are creditors of the estate, many times there's a requirement to publish notice again of the filing of the final accounting. And then you have to wait 60 days from the date of publication before you can move on to try to close the estate. We accomplish that with a petition to approve the final accounting and get that signed. Once we get that done, then we file a petition for a petition that will allow the personal representative to distribute the property of the estate, and we get permission from the court to distribute the property. Then we get receipts from each of the heirs who will indicate that they have received the property that they're supposed to receive. Of course, any cost or expense comes off the top for the personal representative. There's also a statutory personal representative's fee if it's not waived. There's also attorney's fees that are provided by statute or by private contract we usually do estate cases on an hourly basis and sometimes hourly basis versus the statutory allowance, which is a percentage of the estate. And that's what the personal representative gets, is a percentage of the estate as the personal representative's fee. So once all those things have been taken care of, the receipts have been prepared, we file a report of distribution, file those receipts, and get an order allowing the estate to be closed. If there are any deeds that have to be prepared, we have those deeds prepared and filed. And once all that occurs, we're probably on 1.5 years, maybe 2 years. Probably I have been able to do some within a year, but that's a really difficult thing to do with all of the built-in delays with the 6 months and the 60 days and all of those things. But we try to move as quickly as we can. Once we get the order closing the estate, everything's been distributed, the estate is closed. We get a little sheet from the clerk's office telling it's closed. As I said a moment ago, we do transfer property from the personal representative in their capacity as the personal representative to whatever heirs get any real property. So we file those deeds, of course, before we close the estate. And then we're done. And so I didn't go into as much detail, and I didn't go into every issue that can arise during an estate case, but there are certainly, as you can tell, there is a lot to do during a probate. And I enjoy the work. I enjoy helping families go through the probate process and kind of jump through all the hoops necessary to make that happen. And it is completely valid to have a will and to go file it and to go through probate. There is an easier way, and many times I'll get a question from, if it's a child and they're the personal representative of their parents' estate, they say, Jay, is there an easier way? Can I help my children avoid having to go through all of this work that was necessary and all the expense that was necessary for this probate? And that's usually when we talk about the revocable trust. And revocable trust is a great instrument that allows you really very simply to avoid that whole probate process that I just discussed. But let me say this before I talk a little more about the revocable trust. There is a famous author, and he just wrote an incredible book. I think I've read almost all of his books, and I have now read his newest release, and it happens to be about an estate attorney, about a probate attorney that has a new client. An elderly lady comes to hire him to do a simple will, but she tells him that she has $18 million. It turns out, well, I'm not going to say that because you need to read the book and I might be giving something away. But anyway, but over the course of time, he finds out that not only does she have a whole lot of money, where there would also be estate tax implications for her estate, she also doesn't have any heirs. Her husband passed away, and he had 2 sons. She had 2 stepsons, but she didn't like them, and she didn't trust them, and she didn't want to give any money to them. She was very secretive about her money, and not many people. She lived very humbly, a very frugal lady, so no one even knew she was rich. And so she came to this attorney to do this will, and she was trying to figure out what she wanted to do with all of her money. Let me just tell you, I have never had that happen in 28 years where you have some person with a lot of money who has no one that they want, or no institution or charity or loved one or anyone that they want to do something with their money. So it's a pretty good fiction. Most of us actually get involved and engaged in estate planning because, and very few people come in with $18 million that they're trying to deal with. But we do that because there are loved ones that we have. There are the people that we intend to leave behind, and we want to make sure that what we've worked hard for all our lives, that it goes to them, and that as little money as possible is taken up by administrative costs, by all the costs to probate, the cost of the attorney's fees, and all of that. So we thankfully and hopefully you have loved ones, unlike the lady in this fictional book, that you can leave your property to, and so that may be why you would tune in to this webinar to try to get some more information about it. So when I was talking about the probate process, you may have tapped your wife and said, "Nancy, there's no way that I want our children to have to go through all that." Is he going to tell us some way to avoid it? And I'm going to do that right now, and it's called the revocable trust. And when we create a trust, we're basically creating a vessel like this coffee holder, and we're creating a vessel to hold your property. And we like to fill that vessel with your property. And there's a lot of property that we can put in the revocable trust before you leave our office. And so it's important with the revocable trust, and in talking about that, there are other kinds of trusts. There is an irrevocable trust, and sometimes for estate planning purposes to avoid some of the penalties that might come later and some of the risks involved with health and claims that could be made against real property and spending down personal property, that people consider irrevocable trusts where they actually separate themselves from their property. And that's a valid thing to do. We do a lot more revocable trusts that are completely aimed at simply avoiding the probate process. It's not an instrument that separates you from your property. It's revocable, meaning that you control it, you control the property in it. As a matter of fact, there are 3 offices created by a trust. There's the beneficiary, the person for whom the trust is set up for their benefit, the trustee, the person's managing the trust, and the settlors, those that create the trust. And in the revocable trust that we set up, if it's a husband and wife, the husband and wife each serve in each of those capacities. They're the co-trustees, they're the co-beneficiaries, they're the co-settlors. And if it's a single person, then obviously they serve in all 3 of those offices in their single capacity. So you serve in those positions and you set a trust up for your benefit, but then upon your death, you have appointed a successor trustee, and in some ways the revocable trust looks a lot like a will. The only difference is that trust is holding your property, and when you pass away, rather than going and filing a will and going through a probate process, the property is distributed from the trust. And usually, unless there's some dispute over the trust, and I've done this long enough that I will tell you, sometimes there's disputes over trusts and you have to get a court involved. But if you prepare the trust well, and most of the time allowances are made for heirs and for creditors and different folks, if it's drafted well, usually there doesn't have to be a court proceeding for a trust, as long as all the property that is owned by the person creating the trust is in the trust. And we execute the deeds to any real property, land, houses, in our office. We prepare those documents, and then we file them in the county where the property is located. And once those deeds are recorded, the property is inside the vessel. It's inside the trust to be held for the family member that you're leaving that property to, held for your benefit, and then also you can pass it to who you want to leave it to. We also address personal property, especially tangible personal property, things like furniture, clothing, tools, jewelry, whatever it may be. We do a blanket assignment of the personal property into the revocable trust. And so a bunch of your property, both real and personal, are in the trust when you leave our office. Now, there are other types of property that you have to actually go and do something in order to make that, to cause that to go into the trust. But we, as I say, every time we sign the trust and we put as much as we can in this conference room, and a lot of people take me up on it, but call me, because I can talk to any bank, we can talk to anybody that services any insurance policy, retirement accounts, stockbrokers, One area that I wanted to say something about tonight is also a lot of people are small business owners, whether it's a corporation or an LLC, and we have a plan also to deal with the ownership of those business interests when you're dealing with your estate planning, so that we can try to deal with those so that there won't be some business interest that you have that would cause you to have a property interest that would have to be probated. So we work on that as well, and it's not real difficult, but it can be rather more involved. We have to try to review the controlling documents of the corporation or the agreement for the LLC, make sure that we follow the controlling documents of the business, and so that it will tell us how we can put that property, how we can deal with that property in such a way that it will not have to be probated upon the death of the interested party, the person owning that interest in the business. So those are some things. I covered a lot of the nuts and the bolts of the revocable trust and every document that we offer in our package back in October. I would really encourage you to take this webinar, listen to the one in October 1st, and then listen to this. That was sort of Revocable Trust 101, and this is kind of Probate 101 with a little information on revocable trusts. So I get the question a lot, I may get it tonight, is do you still do wills? Yes, we still do wills. And as a matter of fact, when I go through all the different options that folks have, and I covered that a little bit in October too, the different options that you have, some people still elect to do a will. It's less expensive to draft, and usually it's if it's a husband and wife, they just do reciprocal wills. Upon the death of the second, everything goes equally to their children. That's a pretty simple equation, and so we still do those. We still do wills, and some people, as long as they embrace the probate process, and then we're happy to do the will. I will say that while a revocable trust is a little more upfront to create, it is much cheaper than going through probate. Much cheaper than going through probate. So I didn't want to keep you for a long time tonight. I wanted to kind of explain the probate process. I do want to try to reserve some time for questions. And of course, it's much easier for our in-person guests to ask questions than it is for folks on the webinar to ask questions. I get questions sometimes. I think the most common question that I get is about expense, and because there are differences in what is needed and what all goes into the trust, or talking about the different options that you have, and some people elect different options. We don't usually talk specifically about what the cost is. We do almost always do them for a flat fee, however, and right now for revocable trusts or wills, if you decide to do the will package, we're giving you 11% off of the flat fee through December 31st. And so I've been asked, why would you do that? Well, some people, the best gift. Okay, so let me just speak to guys, and you always run a risk when you do this, because there may be a couple and it's just the opposite. It's the wife who needs to do this to get this for the husband rather than the husband for the wife. But it has been my experience, of all the gifts that I've given my wife, whenever I drafted our estate documents and took those home to her, I don't think that she was ever more happy or pleased with me than she was when I made that trip home. Now, part of the issue is I'm not trying to be a procrastinator, but you've heard the story, the cobbler's children have no shoes, and that's kind of the situation when you do a lot of this work for others. Sometimes you're the last person that you end up doing these documents for, but I did draft these for my family, and I can't tell you how happy my wife was and how at peace she felt when we got this taken care of. So it is very important, and whether you're that young couple and you have that child and you want to try to designate who gets custody of your children, Should any terrible, the worst thing happens and you're not here to raise them. I get young couples coming. I get folks that, as they really at any age, but we certainly prepare a lot of those for young families and as folks get older. And older, I was in my early 50s when I did my estate documents, which I think is really young. And if you're 20-something, that sounds really old, but trust me, it is not old. I don't know what old is. I think old is usually about 25 years older than I am. And so it's a moving target. But regardless of your age, I had probably one of my favorite clients and favorite stories is when you're an older lawyer like me, Drew, you tell war stories. And so I have to tell this one more story. I did just a basic will for this gentleman, and he was 94 years old, and he drove to my office to execute his will with his 93-year-old girlfriend. 94-year-old man with a 93-year-old girlfriend drove himself here, executed his will, no question about his competence. But I will say that is my only client ever in their 90s that executed these documents. So you probably don't want to wait till you're 90 to execute your estate documents. But I would be more than happy. We have free consultations if you need more information. You say, hey, I have some specific questions or I have a strange situation. The best thing to do is to give me a call. We're going to put the information on the screen. You can send me an email, send me a text. I would be more than happy to sit down and visit with you in person. We block off an hour to go through all this. And you say, man, that's a lot of time to spend with somebody that may not hire you. That's okay. We really want folks to have all the information. So once again, we're so excited to get to talk with you tonight. And I tell you, it's amazing to me on a Tuesday night that people are willing to tune in and watch. So thank you for doing so. It's such a blessing. God bless you. Enjoy this holiday season. Enjoy Christmas, the New Year. Thank you.